Repeat visits, and a number of you are here for the first time, so again, welcome. Our conference is really an International Law Department team effort, and so I'd like to thank all the members of our department for all their efforts during several relatively hectic weeks, as well as their efforts throughout the year. In particular, I want to thank Derek Jinks, our current Stockton professor, who's chaired our conference committee. Thank you very much, Derek, for that, as well as your contributions throughout this academic year. Mike Karsten and Jane Van Petten have led our team of our logistics team. Mike, this is number 4 for you, is that right? Thanks very much to you and Jane and to all the members of your team. There are several organizations I would like to thank up front for their financial support of this event. First of all, the Naval War College Foundation, and secondly, the Israeli Yearbook on Human Rights, represented by Professor Yoram Dinstein, who will be joining us this afternoon. And now a special thank you to our co-sponsors, University of Texas School of Law, represented by Bobby Chesney and Derek Jinks. Gents, will you please stand so we can recognize you? Thanks very much. The International Institute of Humanitarian Law, represented by Colonel Darren Stewart, British Army. Darren is the director of the military department of the Institute. Thank you very much, Darren. Liber Society on the Law of Armed Conflict of ASIL, represented by its chair, Dick Jackson. Thank you, Dick, for joining us. Our speaker introductions today are going to be extraordinarily brief, and I invite your attention to the biographies that you each have been provided. At this time, I'd like to introduce our panel moderators. Our moderators will be introducing the speakers in turn, and thanks to all of you moderators for helping us organize the panels. Please stand when I call your name. In some cases, the moderator may not have actually been seen by the speaker, although they've communicated by email and phone, so I'm going to make sure that the speakers can recognize the moderator. Captain Stacy Pedrozo, JAG Corps U.S. Navy Naval Justice School. Charles Garraway, former Stockton professor at the college, currently with the British Red Cross. John Murphy, another former Stockton professor, currently from Villanova School of Law. Where are you, John? I can't see you. Not here yet? Okay. Dave Graham, Executive Director of the Army's, I wanted to say JAG School, Army JAG's Legal Center and School. Did I get that right, Dave? It's hard to break old habits. And Captain Rob McLaughlin, RAN, who is Director of Operations and International Law for Australia Defense Force. I want to announce 2 changes to our program. Professor Sean Watts from Creighton is grounded back in the Midwest due to bad weather and flight cancellations. And I think most of you know that Ken Watkin, the recently retired Canadian JAG, will not be with us this week. As most of you know, the Israeli government has appointed Ken to be one of 2 international observers to the inquiry or commission of inquiry into the blockade incident. Brigadier General Blaise Cathcart has graciously agreed to substitute for Ken. Congratulations, Blaise, on your appointment. Congratulations in person, and thanks very much for taking Ken's place. Now, concerning the presentations and discussions this week, please note that the conference is being held on a, quote, for attribution basis. Only Thursday's lunchtime session on the military commissions will be held on a not for attribution basis. Also, please note that the proceedings are being taped for a later showing at the college. And finally, so that all of our speakers don't have to do it, please note that the speakers are presenting in their personal capacities. Their remarks do not necessarily represent the positions of their governments or their employers. It's now my pleasure to introduce our conference committee chair and our current Stockton professor of international law, Professor Derek Jinks.
Thank you, Dennis. Good morning, everyone. I also want to take just a moment to welcome you all to Newport, welcome you to the Naval War College. I think that we've assembled really quite a remarkable lineup of legal experts, legal practitioners, a number of interesting perspectives on a number of cutting-edge issues in the law of armed conflict and public international law more generally. We have a packed schedule, we have an ambitious schedule, but I think you'll find that the program is really going to be quite extraordinary. Kicking off the substance of the program is Nicholas Rostow, who will deliver our opening address this morning. Nicholas does not require an introduction for many of you. Many of you know him. He's a former Stockton professor at the Naval War College. He's currently University Counsel and Vice Chancellor for Legal Affairs at the State University of New York. From 2001 to 2005, he served as General Counsel and Senior Policy Advisor to the U.S. Permanent Representative to the United Nations. He also served as Special Assistant for National Security Affairs to both Presidents Ronald Reagan and George H.W. Bush, and Legal Advisor to the National Security Council under National Security Advisors Colin Powell and Brent Scowcroft. Really quite a lengthy and distinguished career in government service and in academia. Please join me in welcoming Nicholas to deliver the opening address.
Thank you very much. It's a great honor, really, to be here, and extraordinary privilege to give the opening address to this conference. The conference is famous for addressing the most difficult and contentious issues in the field of the law of armed conflict, or international humanitarian law, or the law of war, as I prefer to call it. This conference is no different. It's famous also for dealing with these issues in the perspective of real life. These are issues of academic interest, but they're of professional interest and operational interest, and lives depend on them. So it's a great pleasure to be back. And Dennis, thank you very much for inviting me, and Derek for the kind introduction. The issues that we're going to take up this week include these most difficult issues: detention, civilianization of warfighting, the direct participation in hostilities, the use of drones, asymmetric warfare, enforcement and accountability, and I suppose a host of other topics that will invariably be drawn in during discussions, including embargoes and blockades and so forth. It's been called this morning by my lawyer Harvey Rishikoff as one of the great stovepipes of international law. I think that's not doing it a real disservice, but it's a big fat stovepipe with real importance. The issues we're going to discuss divide the United States and a lot of its closest allies. For example, at a recent conference on the condition of international law at Ditchley in England, an American official, in fact the legal advisor of the State Department, was surprised to discover that an awful lot of the people at the conference thought the condition of the International Criminal Court was a thermometer for gauging the health of the entire international legal system. He found that rather surprising, even though he was on his way to Kampala. I think that highlights a difference in view. I'd like to spend the bulk of my talk addressing the recent paper by Philip Alston of the New York University School of Law for the Human Rights Council on targeted killings. It's an important subject. It's a subject that is not going to go away. It's as old as sniping and targeting of people like Admiral Nelson. And it highlights, I think it brings us back to the issues that came to the fore right after 9/11. Do we approach counterterrorism and the combat against terrorists in a law enforcement or mainly law enforcement model, or is it an armed conflict? And the issues of armed conflict, armed conflict itself raise a number of important legal issues, such as the choice of weapon, the target, the collateral damage, the extent of the battlefield, and the definition of the battlefield itself. All of these are central issues. And of course, thanks to the ICJ's advisory opinion on the Israeli fence, a new issue is thrown in the mix. Does a state have a right of self-defense against terrorists and terrorist attackers? And let me make my view very clear. I think Al-Qaeda and other terrorist groups are in hostilities with the United States. The United States has a right of self-defense against them. All states have duties under binding UN Security Council resolutions, treaties, and customary law to suppress and prevent armed attack from their territory. And if they can't discharge that responsibility, the victim state is not without recourse. The recourse can include the use of force in self-defense, and it has to meet the tests, which are not trivial tests of necessity and proportionality. Let me just say that in my view, necessity is, or both these tests involve a rule of reason. One would like to see an exhaustion of alternative remedies, but if it's reasonable to assume that there's those remedies, trying to find alternative remedies will not work, that one is not caught in a kind of suicide pact. And secondly, in my view, proportionality is met by using that quantum of force that's reasonably necessary to bring the situation that gave rise to the right to use force to begin with to an end and to prevent its recurrence. It's not a tit-for-tat situation. I say this because Mr. Alston takes a rather different view, and although he begins his paper by talking about unmanned vehicles and says they're no different legally from other kinds of weapons, guns or bows and arrows or whatever, nonetheless, his view is that one needs to examine each attack individually because his perspective is that of an international human rights lawyer, and he superimposes on the battlefield and on his analysis, I think, international human rights law, which raises questions about, which he doesn't analyze and doesn't answer, about when international human rights law governs and when the laws of armed conflict govern. Further, he doesn't anywhere in his paper examine what exactly is international human rights law. Is it customary, and if so, what is customary about it? If it is treaty-based, which treaties and which states are parties, which states are not parties, and what issues arise from that fact. So one is left, or at least I was left, reading it rather perplexed. He makes an important statement that each attack individually and must be examined against the tests of proportionality, and that it's not for overall military operations, the test of proportionality. He thus elides, in my view, the use in bello and the use ad bellum, with unfortunate results if you're trying to figure out and use his paper as a basis for analyzing proposed operations and making targeting decisions. He thus takes a rather limited view of what the battlefield is. For example, in his view, a legitimate target is a fighter, not a farmer, except when the farmer is fighting. So that a farmer by day, a fighter by night, is a target only when he's a fighter at night. Does that mean a soldier in his bed is not a legitimate target? It's an approach that comes right out of Additional Protocol 1. The United States, of course, is not a party to that protocol, in part because it favors terrorism. My lawyer would have me say it arguably favors terrorism, but that's not my view, that's his view. The Alston approach adopts the ICRC position that that's a kind of stop and start with regard to persons who directly participate in hostilities. They may do so every other day. It's that every other day when they're directly participating that makes them a legitimate target. He doesn't take up the whole issue of command, of planning, but rather says financial support is too attenuated, advocacy is too attenuated, et cetera, so that it's a very, very narrow concept of who and what is a legitimate target, and I don't think that it's one the United States, for example, can readily adopt, and I suspect a host of other countries that find themselves in military situations can't adopt it either. It's interesting that the UN Security Council, which has adopted a slew of resolutions on terrorism, for political reasons, has included in the list of sort of 4 examples of international law that govern international human rights law, but it's always in a laundry list, which was created as a matter of drafting compromise, and so doesn't get in the way of operational requirements as a matter of analysis, and Mr. Alston simply ignores all of these resolutions. And they're important because most of them are binding on the international community. They contain paragraphs that begin with the word decides. They're decisions under Article 25 of the UN Charter. And they don't define terrorism. What they do is to say this act is illegal, that act is illegal, and when you're done going through the list, there's not much that a terrorist can do that isn't illegal. And so by a form of indirection, the international community, which is unable to define terrorism directly, has done it indirectly. And all of this is ignored by Mr. Alston. But then he's working for the UN Human Rights Council, and having just been completed an analysis of the so-called Goldstone report, I certainly was not surprised by what I found in the document. The U.S. position, of course, is quite different, and Harold Coe, the legal advisor, recently set it out in a speech at the American Society of International Law. Very importantly, he asserted categorically that the United States is in a number of armed conflicts in Iraq, Afghanistan, and with al-Qaeda and other terrorist groups around the world. He was unapologetic in asserting that the United States had a right of self-defense and was engaged with these groups in combat in exercise of that right, and that planners of attacks and others were legitimate targets, and that the use of drones and other unmanned vehicles was warranted and useful because they're very precise weapons and they can reduce the likelihood of collateral damage so that one can really get the target one intends. Now, Mr. Alston raised the issue about process, and there should be a process in his view that for the verification of intelligence, one shouldn't be able to define a target at will, and of course that's always a problem, but we don't live in a world in which governments are likely to let third parties vet their intelligence or make such decisions for them. So we have to look to our constitutional processes to ensure that at the end of the day, everyone making these decisions knows that they have to act responsibly and lawfully. And I think that in the while it's true to some extent, as Charles McGarry, the novelist, said, that counterterrorism is like Tyrannosaurus Rex. It eats anything that moves. And an awful lot of people have added, like Christmas tree decorations, agendas that have nothing to do with counterterrorism to the whole counterterrorism effort. Nonetheless, I think that in the area of intelligence and warfighting with terrorists, the United States has no interest, and nobody should have an interest in targeting people who are not terrorists and getting the wrong people caught in the counter-terrorist effort. Now, Mr. Coe's remarks raise one of my pet issues, which is the impact of technology on the right of self-defense. If a state has precision weapons, is it obliged to use them? If a state does not have precision weapons, does it lose its right of self-defense because it can't control the collateral damage? My uncle was worked in OSS and was on targeting specifically heavy water plants during World War II. And he said that using World War II technology and going after the communications center that was destroyed in the first minutes of Operation Desert Storm in 1991, he thought that we would have leveled Baghdad and missed the target. So that raises a really interesting question. If you're a country under attack and don't have precision weapons, are you precluded from exercising your inherent right of self-defense? I would say not, but I'm sure there are others who would disagree. Mr. Alston also raises the issue, which has become a hot one in some circles, as to the role of the Central Intelligence Agency in directing drone attacks at a distance. And the question that a number of people have raised is whether or not CIA personnel are combatants who are protected by the Geneva Conventions or not. And I find it an interesting question, but there are CIA agents and CIA agents. There are the cloak and dagger folks, and there are the guys who are indistinguishable except from the source of their paycheck from the regular military. And it seems to me that if a CIA person or a State Department person's in uniform, obeying the laws of armed conflict, et cetera, and meeting the standards of the Geneva Conventions, I don't see why they should not enjoy combatant status. But again, this is all stuff that Alston mentions, but he doesn't talk about. I think we need to do a lot better than this. And this conference, I'm convinced, will do a lot better than Mr. Alston and will push the ball considerably down the road. Counterterrorism is not going to go away. Terrorism is not going to go away as a phenomenon. It's an old one, and it exists because it's effective. It's focused mainly in the Islamic world because, as our current ambassador to Israel, when he was the deputy Perm rep at the United Nations, told his fellow Perm 5 members, until the Islamic world drains the swamp in which terrorists operate and makes clear that there is no tolerance for terrorism under any circumstances, it will have a problem of being identified in the public mind as a source of terrorism. And I think that's right. Every country has had a terrorist problem. Peru, Italy, Germany, Japan, Italy, and other countries, and they've drained the swamp. They have said it is not tolerable. We don't care what your cause is. It just doesn't fly. And until the entire world adopts that approach, we're not going to see an end to this. And therefore, policymakers are going to have to balance the instruments they use. Sometimes it will be law enforcement, sometimes it will be military. Really depends on the context. There are a number of other issues which I would like to sort of close by just flagging for you. One is that often gets forgotten is that not only is a use of force a political act, and for the United States always seeks a political outcome, but the tactical decisions that are made also have political consequences. So, for example, the way we went into Iraq had short-term and medium-term political consequences. If we had used 400,000 troops, there would have been different political consequences, but we didn't, and we had to deal with the consequences that flowed from that. There are a lot of people who were talking about the introduction of judicial process in military decisions. I have been told that the Israelis have kind of opened the door in their country for judicial review of military operational decisions. Certainly there are an awful lot of lawyers in the United States who would like nothing better, and I suppose judges who get bored with their dockets and would like to oversee military operations as well. I don't know. But that's something we ought to keep in mind. So with these few remarks, I wish you all a very good conference. Unfortunately, I have to leave shortly and won't be here for the rest of the conference because I've been summoned to Washington, but not for anything terribly important, but it's important to me. And I thank once again the Naval War College for inviting me, and it's wonderful to be here and to look out and see not only colleagues but people from whom I have learned a great deal as I do my own work. So thank you very much.